The most explosive evidence in the Blake Lively versus Justin Baldoni case could vanish before this trial even begins. The very texts that fueled the smear campaign narrative, the cherry-picked texts, the sensational headlines, the damning headlines, may never reach a jury at all. Not reduced, not reframed, gone. Because this isn't just about reputation anymore. It's about admissibility. It's about whether the court rules that key documents are tainted evidence before a single opening statement is delivered. And this is where it escalates. The controversy traces back to a John Doe lawsuit, one tied to a company owned by Ryan Reynolds, that allegedly secured subpoena power long before the public realized a legal war was forming. What looked procedural at the time is now under scrutiny as a possible sham lawsuit, raising questions about abuse of process and even procedural fraud. If a judge determines that evidence moved through a broken chain of custody or that there was a flagrant abuse of process, the consequences could be immediate. We're talking about sanctions, potentially even Rule 37 sanctions that could strip entire categories of evidence from the case. That means the courtroom battle may be decided before the jury ever sees the messages that shaped public perception. This is no longer just celebrity fallout. It's a legal chess match over who controls the narrative and whether the foundation of this case survives judicial scrutiny. If the evidence falls, everything shifts. Before the public ever saw a sensational headline, before the allegations of a smear campaign dominated timelines, something else happened. A John Doe lawsuit was filed, quietly, strategically, without public fanfare. It named no traditional defendants, it alleged breaches of contract and smearing reputations, and it was connected to a company owned by Ryan Reynolds. At the time, it looked procedural. But this is where it escalates, because that lawsuit allegedly secured subpoena power, the legal authority to compel access to digital material. And once that authority is granted, doors open that would otherwise remain closed. That power matters, especially when the individuals referenced were connected to the Reynolds parties, including figures like Stephanie Jones and Jen Abel. Now, here's the pressure point. Critics of the filing have described it as a potential sham lawsuit, raising concerns about abuse of process and even a flagrant abuse of process. Those claims remain subject to court review, but the language alone signals how high the stakes have climbed. Because if a court later determines that the initial legal maneuver crossed a line, the fallout won't just affect optics, it could affect admissibility. And that possibility is what makes this filing far more than a footnote. Even if every message was obtained, even if every text exists, even if every email fueled weeks of sensational headlines, none of that guarantees the jury will ever see them. And this is where the case could pivot instantly, because the decision does not belong to public opinion, it belongs to the judge. The instrument at the center of this phase is a motion in limine, one of the most powerful pretrial motions in civil litigation. It allows attorneys to challenge admissibility before the trial begins, before witnesses testify, before opening statements shape perception. If granted, the court can exclude evidence entirely, erase it from the battlefield. This is where it tightens. A successful motion in limine doesn't just trim the edges of a case, it can remove entire pillars, text messages, email chains, attachments, expert opinions, all ruled inadmissible if they are deemed unfairly prejudicial, lacking proper foundation, or legally compromised. And that analysis can include how the evidence was obtained. That's the escalation point. Because the court doesn't only ask whether evidence is relevant, it asks whether admitting it would violate fairness standards, whether it complies with discovery rules, and whether proper judicial oversight was followed. If the judge determines that the material qualifies as tainted evidence, the impact is immediate and structural. The narrative built in the media could shrink dramatically. The leverage one side appeared to hold could evaporate overnight. But here's what complicates everything. A motion in limine can be paired with requests for sanctions, and once that door opens, the stakes rise beyond admissibility. If attorneys argue that evidence was obtained through procedural irregularities, they can seek remedies that go beyond simple exclusion. That includes financial penalties, evidentiary consequences, and restrictions that shape how the case is presented to the jury. This is not theoretical. The upcoming pre-trial filings will define which evidence survives, which expert reports stand, and how jury instructions are structured. These filings often determine the emotional ceiling of a trial long before jurors take their seats. And this shifts the battlefield again. Public narrative thrives on explosive excerpts. Courtrooms operate on rules. If the rules are enforced strictly, the material that drove cherry-picked text controversies may never reach 12 decision-makers. If the motion fails, the battle moves to exposure and cross-examination. If it succeeds, the trial may look nothing like the headlines that preceded it. That's the kill switch dynamic. This is where pressure builds, because the ruling on a single motion in limine can quietly reshape the trajectory of the entire dispute without a single dramatic courtroom moment. And when admissibility becomes the fight, the outcome often determines more than the verdict. It determines the story the jury is even allowed to hear. Now we move from leverage to legitimacy. Because even if the motion in limine is filed, even if arguments about admissibility are made, the real battle may center on one question. Was the evidence compromised at the source? And this is where it tightens. In legal doctrine, there's a concept known as the fruit of the poisonous tree. It's more common in criminal law, but its logic can extend into civil disputes when tainted evidence is alleged. The idea is simple. If the root is compromised, everything that grows from it may be vulnerable. That's the escalation point. The controversy here doesn't focus only on what the messages say, it focuses on how they were first accessed. Allegations have circulated that Stephanie Jones accessed material from a device, potentially involving iCloud, and that the data later moved through litigation channels tied to a company owned by Ryan Reynolds. Those claims remain subject to court review, but the legal implications are significant. Because once evidence is handled outside transparent judicial oversight, questions immediately arise about chain of custody, about integrity, about authenticity. Courts require confidence that digital material has not been altered, selectively copied, or manipulated. And that's where pressure builds. If an unsupervised transfer occurred, if there was uncontrolled data movement before formal discovery protections were in place, attorneys can argue that the material is structurally unreliable, not because of what it says, but because of how it traveled. This is not a minor technical objection, it's a credibility challenge. Under a fruit of the poisonous tree theory, if the original access point is found improper, subsequent copies, even those later obtained through court-supervised procedures, can remain suspect. The stain, legally speaking, does not automatically disappear. And this shifts leverage again, because if the court finds that there was procedural irregularity, attorneys may escalate the argument beyond simple exclusion. They can frame it as procedural fraud or as a serious abuse of process, depending on how the facts are evaluated. Those are heavy terms. They carry weight in a courtroom. If a judge determines that the chain of custody was broken or that evidence integrity cannot be reliably verified, the remedy could include exclude evidence orders under a motion in limine or even broader sanctions depending on the findings. This is where it escalates further. The debate is no longer about isolated text messages. It becomes a structural audit of the entire evidentiary pipeline. How was the phone accessed? Who authorized the retrieval? What safeguards were in place? When did formal discovery begin? If those questions generate doubt, the consequences ripple outward. Because jurors do not evaluate evidence in a vacuum, they evaluate trust. And if the foundation is successfully challenged, the persuasive impact of the material weakens dramatically, even if some portion is ultimately admitted. But here's what complicates everything. Even if the court declines to fully exclude the material, concerns about integrity can shape how it is presented. Judges can allow evidence while instructing the jury to consider potential weaknesses. They can limit references. They can impose boundaries. And those limitations can change the emotional force of a case. This is the inflection point. If the root survives scrutiny, the narrative regains strength. If the root is deemed compromised, the leverage shifts, possibly permanently. Because once a court questions the origin, the battle is no longer over interpretation, it's over legitimacy. And legitimacy is far harder to repair. But here's where the battlefield shifts again. Because what if the motion in limine fails? What if the judge allows the messages in? That doesn't end the escalation. It redirects it. And this is where it tightens. If the texts and emails survive an admissibility challenge, the next weapon comes into play. Rule 106, known as the rule of completeness. This rule exists for one reason: to stop selective storytelling. If one side introduces a snippet of a message, the opposing side can demand that the entire exchange be shown to the jury, not just the explosive line, not just the emotionally charged excerpt, the full chain, the context, the lead-up, the aftermath. And that changes leverage dramatically. Because much of the public narrative has revolved around cherry-picked texts, amplified through sensational headlines and reinforced by claims of a coordinated smear campaign. But courtrooms are not social media feeds. Under Rule 106, if a single fragment is introduced, opposing counsel can insist on the complete communication: emails, attachments, timestamp sequences. The goal is simple: prevent distortion. And this is where pressure builds. If the broader record softens the impact of those excerpts, if surrounding messages provide context, clarification, or contradiction, the emotional intensity that drove early coverage could weaken in front of a jury. That wasn't the only complication. The New York Times and other outlets helped elevate portions of the dispute into the national conversation. But media presentation is not bound by evidentiary rules. Courts are. If Justin Baldoni's attorneys argue that the public saw only selective disclosure, that the narrative was shaped by partial release, they can use Rule 106 as both shield and sword. Shield to prevent misleading impressions, sword to expose omitted context. And that exposure could reshape perception inside the courtroom. Because once the full trove is examined, not just highlighted excerpts, jurors evaluate tone, sequence, response patterns. They assess whether alleged coordination appears systemic or fragmented, whether language reads as strategic or reactive. And that evaluation happens under oath, not under headlines. This is where it escalates again. If the evidence stays in, the fight moves from suppression to scrutiny, from exclusion to cross-examination, from procedural attack to narrative dissection. And that dissection can be unforgiving. If the complete record reinforces the smear campaign claim, the narrative strengthens. If it undercuts it, if context alters meaning, credibility becomes the new battlefield. Because juries are sensitive to framing. If they perceive selective emphasis, trust erodes. And once trust erodes, persuasion becomes exponentially harder. This is the dual risk dynamic. Exclusion could shrink the case. Admission could expose it. Either path carries consequence. And that's why Rule 106 matters so much here. It ensures that if the story is told, it must be told fully. No highlights without context, no fragments without sequence, no narrative without completeness. And in a case driven by perception, completeness may be just as destabilizing as exclusion. Now we reach the pressure point. Because if the court determines that something went wrong in the way evidence was handled, not just technically wrong, but structurally improper, the escalation does not stop at a motion in limine. It moves to consequences. And this is where it shifts leverage dramatically. Under federal civil procedure, there is a remedy known as Rule 37 sanctions. It applies to misconduct during discovery, And while not routine, it is one of the most serious corrective tools available to a judge. This is where it tightens. If a court were to find that there was an abuse of process or that evidence moved through channels lacking proper judicial oversight, attorneys can request more than simple exclude evidence relief. They can ask for penalties, financial penalties, evidentiary penalties, structural penalties. That includes payment of legal fees, that can include fines, and in severe cases, it can include instructions to the jury allowing negative inferences about conduct. Those are not cosmetic consequences. They reshape trials, and this is where pressure builds. Because if a court were to grant Rule 37 sanctions, the impact would be immediate. The material central to public controversy, the texts, the emails, the attachments, could be limited or removed entirely. The case would no longer revolve around explosive excerpts. It would pivot toward procedural credibility. That pivot changes everything. The narrative of a coordinated smear campaign would no longer sit at the center of the courtroom. Instead, the focus could shift to whether litigation tactics complied with procedural safeguards. And that battlefield is far less predictable. But here's what complicates everything. Sanctions are not automatic. They require findings. They require proof of misconduct. Courts apply them carefully because they carry significant implications. Judges must balance fairness, deterrence, and proportionality. Yet even the possibility alters negotiation dynamics. If one side faces the risk of sanctions, settlement calculus shifts, trial strategy shifts, public messaging shifts. This is why some attorneys describe severe sanctions as the civil equivalent of a nuclear option. Because once deployed, they do not simply adjust the case, they redefine it. And that redefinition can extend beyond the immediate dispute. If the court finds that procedural boundaries were crossed, if it determines that evidence integrity was compromised or that discovery rules were violated, the precedent effect matters. High-profile cases often influence how aggressively future litigants test legal boundaries. This is no longer just about Blake Lively or Justin Baldoni. It becomes about enforcement, about whether courts will tolerate aggressive evidentiary tactics, about how strongly the judiciary protects procedural structure. And this resolves one of the central loops. If sanctions are granted, leverage collapses for the side relying on the disputed evidence. If sanctions are denied, the case proceeds with that evidence intact, and the battle shifts back to persuasion before a jury. Either way, the ruling will define the terrain, because once the court speaks on sanctions, the strategic uncertainty narrows, and in high-stakes litigation, narrowed uncertainty is power.
Now we zoom out. Because at this stage, the fight is no longer just about individual texts or isolated filings. It's about precedent, and this is where pressure builds. If a judge rules decisively on the motion in limine, on sanctions, or on the integrity of the chain of custody, that ruling doesn't just affect Blake Lively or Justin Baldoni. It sends a signal to litigants, to attorneys, to corporations, to public figures. This is where it tightens. The dispute began with a John Doe lawsuit connected to a company owned by Ryan Reynolds that allegedly secured subpoena power before the broader conflict became public. That move is now being examined through the lens of judicial oversight, discovery, and potential abuse of process. If the court determines the strategy complied with procedural rules, it validates aggressive pre-litigation maneuvering. If the court determines boundaries were crossed, it may reinforce structural guardrails around digital evidence. And that distinction matters far beyond this case. Because modern litigation is increasingly digital. Text messages, emails, cloud storage like iCloud, private communications becoming public exhibits. If courts signal that evidence obtained through indirect litigation tactics faces heightened scrutiny, future actors adjust behavior accordingly. That's how federal precedent is shaped, not always through dramatic Supreme Court moments, but through high-profile district rulings that influence how far parties push. And this shifts the battlefield again. The case began as a reputational clash, fueled by allegations of a smear campaign and amplified by sensational headlines. But it may end as a structural statement about procedural limits, about privacy, about fairness, about the integrity of the justice system. This is where exposure expands. If the evidence is excluded, critics may argue the legal system protected process over publicity. If it is admitted, scrutiny moves to the content and credibility battle before the jury. Either outcome becomes part of the public record, and that record influences how future high-profile disputes unfold. But here's what complicates everything. The optics are layered. On one side, supporters may frame aggressive legal maneuvering as strategic and lawful, a chess move in high-stakes litigation. On the other, opponents may frame it as overreach, as abusive litigation, as an attempt to gain leverage before the merits are tested. Those competing narratives won't disappear after a ruling. They will evolve. And that's why this moment matters. Because whether the court reinforces procedural discipline or allows aggressive evidentiary tactics to stand, the ripple effect extends outward. This is no longer simply celebrity litigation. It is a stress test, a test of how courts balance digital access with procedural fairness, a test of how far litigation strategy can stretch before judicial correction intervenes. And when the ruling comes, whether it centers on admissibility, sanctions, or evidentiary integrity, it will define not just what this jury sees, it will define how the system responds to the next case like this.
Now everything comes down to a ruling, not a press conference, not a headline, not public opinion, a ruling. Because whether the motion in limine succeeds or fails will determine what the jury is even allowed to see, whether the alleged smear campaign narrative survives courtroom scrutiny, whether the contested texts remain central or disappear through exclude evidence orders. And this is where it tightens. If the court finds no procedural violation, the case moves forward with its most controversial material intact. The battle shifts to persuasion, credibility, and cross-examination. If the court finds tainted evidence, broken chain of custody, or serious abuse of process, the consequences could extend beyond simple exclusion. The possibility of sanctions, including Rule 37 sanctions, would reshape the leverage on both sides. Either way, the decision won't just impact Blake Lively or Justin Baldoni. It will signal how aggressively courts police discovery, how they evaluate digital evidence sourced through complex litigation pathways, and how strongly they guard the integrity of the justice system. Because once a precedent is set, whether formal or practical, future litigants adapt. That's the real stake here. Not just who wins, not just who loses, but what boundaries are reinforced in the process. When this ruling arrives, it won't simply determine trial strategy. It will define the narrative that survives judicial scrutiny and the version of events the public ultimately remembers.